the petitioners shall also disclose the documents as to their training qualification, if any, taken by them. The training qualification documents, if any, shall also be in documents from the petitioners. Why this is important, as I progress, your Lordship would find. Kindly take the next order of 20th of December 2022 at 418.
Yes.
The case of the petitioner in short is that though the petitioners got higher marks before addition of marks against interview and aptitude test, comparing to some of the candidates who have been given the appointments against 2016 recruitment process, ever after adding their marks for personality test and aptitude test, they have not been given appointment. Please mark this last sentence of the court. The petitioner's case is that interview was also held, aptitude test was also taken. But why this is important, I'll come later on, because the judgment proceeds on the basis that no aptitude test was taken and the honorable judge had called witness and the witnesses. A complete unknown procedure. Allegedly in excess. Or under section 165 of the Evidence Act. But please mark this, that it is the case of the petitioners that adding the interview marks and aptitude test marks given to them, they were not given appointment. This is the recorded case. Though, my lord, it's not there in the writ petition, I had placed the entire writ petition before your lordships. They have come before this court as have been submitted after taking inspection. I'm sorry.
Though the petitioners got higher marks, this is higher marks on which evaluation? This is prior to the interview.
No. After completion of the process, according
that though the higher before addition of marks for interview and written.
Yes.
So prior to this interview and aptitude test, there was any further rider?
My lord, as your lordships know, my lord, there are certain marks for academic qualification which is added. These are those marks which, upon addition
of academic qualification, they got higher marks.
This is their case. But what is very important over here is, finally, my lord, the honorable court has not gone into this. The judgment which is under appeal before your lordships proceeds completely on the basis that no aptitude test was taken, therefore entire process is bad. I'll come to that, but this is very important. How, my lord, the stand is getting changed from time to time. Therefore, my lord, the first positive assertion is recorded in the order of 20th of December 2022. They have come before this court as has been submitted after taking inspection from the records produced before the Honorable Chief Justice's court in a public interest litigation, and they have also got some input from the publication of marks of the empaneled candidates. In respect of WPA so-and-so, the present one, the petitioners have prepared a tabular chart of 139 candidates, and the petitioners submit that all those 139 candidates have got higher marks than the last employed candidates, but they have not been given appointment. Pausing here for a moment, this point also I will be taking, that these tabular statements, my lord, are not has been petition. Mr. Raj, the board, sometime to check the marks of so-and-so, making appropriate submission so-and-so. For this purpose, I fix so-and-so. Along with the matter such and such, are being moved. I did so in addition to supply similar tabular sheet to Mr. Biswas. Biswas will come after verifying. Mr. Biswas is also directed to come with the tabular form, etc., etc. Then please take me the next order. This is very important for me. 17th of January 2023. Kindly simulate the turn of events from here. But as I said, Millard, your lordships,
Yes.
but I would invite your lordships not to only confine to the merits of the judgment. The procedure which has been adopted in the adjudication of the instant writ petition is very important, Millard. Otherwise, Millard, for the future, Millard, this will remain in the records of the Calcutta High Court.
Page, which
page, এই পেজটা বলতো? Page 421, 17th of January 2023. A serious allegation was petitioners that in the syllabus of 2016, when the stage of interview and test came, only interview was taken and there was no aptitude test. Though in aptitude test there are 5 marks are there also for interview, contrary to the previous days Millard recording. Please come back to Millard, the previous order.
both were held.
Both were held, marks were added, and thereafter people who got lesser marks were appointed, petitioners were deprived.
Herein they say that there was no interview.
No aptitude test. Interview was taken, but there was no aptitude test. Though in aptitude test, there are 5 marks. Or under the rules, Millard, for aptitude test, Millard, 5 marks are allotted. Interview 5 marks, aptitude test 5 marks. So a completely contrary case. I do not know who has made out, but it is recorded. Now kindly see, Millard, the Honorable Court takes upon itself the power under section 165 of the Evidence Act. As a large number of petitioners were present in the courtroom, this is the reason. So many petitioners are before your lordships, therefore, Millard, the law is going to change. As a large number of petitioners were present in the courtroom, I decided to exercise my power under section 185 of the Indian Evidence, and I asked some questions after administering oath to 7 of such candidates, being petitioner numbers, etc.
Yes.
Millard, section 165, as your lordships know, Millard, this is exercised by the court judge. Seat some points which may have been left out by the prosecutor or the cross-examiner, or to get some clarifications if required, or if the court finds that the cross-examiner is not putting the right questions. Now the court, Millard, takes upon itself the burden, in my very respectful submission, a misconduct burden. Pardon for adding this of exercise of powers under section 165.
Yes.
First, Millard, the judge holds the trial. Then the trial is over in the next sentence. Please have a look to that.
Yes.
The next page, Millard. From their evidence, I am satisfied that there was no aptitude test for the said petitioners. Trial over. Finding given.
Yes.
Learned advocate for the board has submitted that he does not have any idea whether such aptitude test was taken or not. In such circumstances, now my lord, the court is eliciting, my lord, documents, evidence. In such circumstances, I direct the president of the board to file one case from the date disclosing whether there was any aptitude test in 2016 selection process and what is the method the board is following this year to take the aptitude test of the candidates. It goes, this year means, my lord, it goes beyond the writ petition. This was 2023. When, my lord, the 2022 recruitment process was ongoing.
No, after this 165 episode, your advocate was asked that you submit the documents. Writ court cannot call for documents, Mr. Datta.
Yeah, definitely. The writ court has the power of certiorari. Writ court can definitely call for documents, but not allegedly after exercising power under 165. My lord, your lordships have the power. In a case, my lord, your lordship finds that there is some disputed questions of fact which can be resolved by way of production of documents, because disputed questions of facts are not always barred for adjudication by the writ court. No quarrel on that issue. But situation under which, my lord, the writ court exercises its powers in adjudicating disputed questions of facts are where your lordships find that from the documents on record, a disputed question can be adjudicated. And for that purpose, my lord, one or two documents here and there missing, your lordships may call for that.
You did not challenge these orders at that stage.
No, these were not challenged.
Yes, next, what you want to say?
Yes. Then, my lord, the president of the board is directed to, my lord, file an affidavit that was filed. I'll take your lordship, my lord, in the pleading sequence. Now, kindly take note the next order dated 24th of January 2023.
Forwarded order. Yes.
I direct